Abusia, yabema kwa ba shonko so aba POG Media so yade meko political highway so highway ne de ensem bebre wo so a yenso ya je penese ebe me abedwafo no ahudie eko ene de eba na den na eko so our political highway so abusia eye enrada eye Supreme Court etina say eye Bagbin Speaker of Parliament and Supreme Court hon sense no na abusia omotina ase wie no Chief Justice and Mukwase Akanopoto, international media about release I expose Chief Justice Busia, Yen Simon Rennie, but perceive me a bit of fun by me a corner paputi and sma, of course, na Bagbin there, man, dear Uchna Brani pa, Hansa Nebecono, oh, and some can be a fast share your comment section like na share my phone so answer into me and can be Madamase.
Oh, inti the end of your court. So I'm for ya tin sembebre say ende eye afenyo marking MPP for court no asana kopie Supreme Court ema sebio or konya or the ex party application because Supreme Court say eye Speaker of Parliament Bagbin why adebi of parliament we yi MPP fo bi omo ko independent no we yi omo to akonwa nti NPP minority leader eye afenyo marking eko eye Supreme Court eko ka kire Chief Justice say Chief Justice Jumadia omudi no eye parliament no Chief Justice entu ni nansim if you say Chief Justice ne betuma aboa no afenyo marking court no Chief Justice onim eye Parliament almost Jumadia omudia sebio omudi omohono otu ne nan ena odi sim say eye decision bia eye Speaker of Parliament Bagbin etekino eye Supreme Court Chief Justice Torkornoo edi enimu no ono wetu ne nan sim judgment ana ruling na oma o Parliament say NDC for ena from time oma sa judgment no eye majority no ono eye Chief Justice ene sebio judge for mo hono omotu omu nan sim Asamono ene eye Bagbin so be 2 days ago ono so ewu krata eye Supreme Court for the bre no e ka kire ne say oh eye wo decision ene wo dwumadi a wodi in the parliament no even though no mo ye independent body a mo aso mo hyemra e make sure say Ghana na ye kikire no bibia ekoye no omo wo akwanya say omo betu omo na esim iti Bagbin also received this suit from the court, the Supreme Court. And our directing the lawyers say, Omunko Supreme Court go can't a Chief Justice say. Jumadie na ordino Supreme Court no. Sa to me ne kutano no. Or no Bagbin the parliament so the same to me. The same as the executive. Inti no one was say asema AC parliament no. Asema parliament ka omankasa betuma tena se aka. Parliament wo ono ankasa ne mra obetube diso ahyehye mra no. Se parliament kura asem siwo na se sebio omonti omo ho ase a omo bibia ye frɛ no rules and regulations standing orders a omo betumi de asolve asem no o say Chief Justice etumi tu ne nan esi omo asem no ohun se Chief Justice watra nani nton sebio ni tumi no oma ni tumi no atra na no sebio oma ni tumi no atra nechi sebio oba na tebe mu dodo. In fact, Emrana Chief Justice ejina so edi akase onja ni dwumadi a odi no parliament no mra bia etia Ghana mrakase constitution no. Yes. Okay. Thank you very much. I will use that. The 5 Supreme Court judges no ban omudin wa 1 2 3 4 5. 5. I'll mention their names now. Enti Assembly Sakopie Court, Bagbin, Esman the lawyers, mom responding to a Supreme Court, a court Chief Justice war. Now, and the Assembly P Court, no TV so. Me assure self from watching kono, let me land the phone be beba. I bet to brofwake see jargons, so I'm for intina me ye win coming yet. So I'm for intina me ye win. Now, after your marking a Supreme Court, ko can asem chire eye osono maame eye Madam Torkornoo a ogirimuma MPP o eye Supreme Court no. All kono asem o de call e ho nyina ne say eye de let me put this picture up. Na yenko yenim. This is the Chief Justice and ono ena odi enim. afenyo makin ede na asem ekọ Supreme Court no okoka kire Chief Justice say eye nipa miensa bia omo Parliament and Alban Bagbin atwe omoto ase akonwa se omoko independent dia eye akonwa na ewo ho no sebio omo ja akonwa na to eni se omo from se omo ye MPP MPs na emom omo ye independent. Now afenyo makin koye no enkura na nka oso kobo Chief Justice no they see your Parliament and say eye nipa 9 MPP form yensa na NDC ni baako na so afenyo makin eko eye Supreme Court no or the nipa miensa din ne call ye say sa nipa miensa we nkoa na eye Speaker of Parliament ehwe ho bua asem of Parliament na so ukọ Parliament nkrata mu a Parliament nkrata mu no sa da na eye Alban Babin ebu asem no na eye nipa 9 ehwo asem e na ogina so ebu a na asem na so afenyo makin eko Supreme Court na okoka na asem a kire eye osono maame eye the Chief Justice no okoka chen say nipa miensa it means say in the first place the ex parte application na afenyo makin edico Supreme Court no that application no everything in it was a lie because don't say court okokota in some na yede ko yenyi bi mfrim ene enfa bi nka ho afenyo makin ekokota no o decide say inkuro ananyoma ekoso Parliament ema Alban Bagbin gina so ka say 4 MPs ye omoto akonwa efiso omoko independent no ono every Parliament ede na asem akọ court ede akọ osono maame ho no o say nipa miensa enho asem na Alban Bagbin gina so ede bu asasem no court so anase eye emrahwe Supreme Court Madam Torkornoo osono maame da ano no eye facts and ye gina so edibu asem. Now the ekosi nyina ne say asem na kopie court na ende the epie court nyina ne say Alban Bagbin show letter come Supreme Court Chief Justice say uni ho kwan in fact muni ho kwan krampo say the ekoso Parliament no mubetu munan esim enti enho ena Chief Justice eye osono maame Madam Torkornoo ene the battalions miensa amaka no etena ase se omu bebua sa asem no ansana asem ankasa afenyo ma akende baaye se Chief Speaker of Parliament say eye omu ye minority anase we yi MPs miensa to akonwa no yakoso into the end e course no nyina ne ye interlocutory eye issues a eye fa asem no ho e de se we twa material enwa homa no enende eye osono maame Madam Torkornoo ene the battalions no etena ase edi hu enkomo enti adekudie nti omotena ase ndan ne se na omopese omotie Alban Bagbin se bi oni response of the bro se omuni hu tumi krampo se omobetena asem no so na omotena asem no so no eye osono maame Madam Torkornoo ene eye the Supreme Court judges omaka baako ye MPP foot soldier your friend eye gawu anase de mebodi din eye Nansia ne Akuffo eye the Supreme Court judge na obi anim so oye former MPP parliamentary candidate Ghana ni mako Ghana ni mako mo Supreme Court judge oye former parliamentary candidate ema political party in power e de akurofon so no now yonko enim enti eye lawyer ogina muma Speaker of Parliament eye Theodore sorry one eye Attorney General onu so gire mu ma Ghana ena ende omu nyina ekopie eye de Supreme Court. Now ye kika asem ni nyina besie no na as a Chief Justice person o kire se owo hu tumi Supreme Court ni wo hu tumi se omu ye de omu pe omu frɛ Alban Bagbin the decision bia o taking wo o taking wo eye Parliament bia no omu wo hu tumi in fact constitution ma omu ho kwan se omu betu omu ndan sim na omu akire de o se Parliament eye enintina omu pese omu koso no omu kodi asem na nkasa nti ende no the adekodie nti omu tena ase ne se Alban Bagbin mu aye o de bro omu se omu ni ho kwan se omu bedi asem no omu se omu abo atogu omu ho kwan na ensem no se ne bobo baaye no moma yenya abotire na yentie sene ye koye sene be asoamefo enso beti ase pefe ansana eye please let me land. I know you are my elder brother. We all went to law school together. You have been a friend for a long time. We know your party affiliation. Ansana sankwasiafo na ba ochina enti ye ne local ejudwom basic na ya mama hu de si wo Supreme Court nde na ya kyerɛ mo sɛnea ɛyɛ ɔsono maame Madam Torkornoo egina pintin ka no totwomyɛ ye na adwun sɛ obɛyɛ adwuma ama Akuffo Addo na sebio ɛyɛ abomu ɛyɛ thank you Akuffo Addo ye Chief Justice no ɔde bɛma ne back. Now so wokɔ de si wo court na time my Chief Justice kasano. So wotie Chief Justice here uhwe enkrata afenyoma ken ede call eye Supreme Court ene ne starting free ye de yen call law school but your common sense ene na we Ghana ni na wo hwe me a you don't have to forget call law school en kire se nyansa unibi ena sebio ye ka asem a se e court o se out of court o se ye mra o se nya mra o at the end of the day everything dwells on common sense. And you don't have to be a PhD holder. You don't have to be a lawyer. You don't have to be in law school to understand fundamental or basic reasoning and logical reasoning issues. And you don't have to struggle to use your common sense. And I make a say on this platform, what we try to do is say we bring everything down to the basic reasoning level. We are Ghana and Inautia because asem we de emunyansa no ene dien adentina simesi we ye say anything every time we bring the conversation to your level inti brofo mo kekan bebrebe o court nde no me ena mabetena ha ne me team ena ye de ba fo ma wate ase because na ye Ghana ni a wokoto aba wo taxes ene ye di tuan kofo mo te court ne ka inti I was said ye course so court no so no at the end of the day no o ye den wote ase. Okay, now there's one thing you need to understand. Say, I'll be to court and I'll be to parliament. Eka constitution. 1992 constitution. I also who be and there's one thing I Ghana for Mure Yefi. Ghana constitution a mason for a hairdressers, a welders, a ma omoton adwini wodwom, omoton apofe, a tailor for a student, a teacher for different kinds of artisans. Ghana for ordinary Ghana for ne G or my journey. The constitution. Nobody in this country should see the constitution say you're too free. 1992 or before 1992 no nipa bi ene to omugu Ghana in penfo mo Ghana ene omje Ghana for adwenkyere efa nyoma ana sene omo pese ye kyekere Ghana. It is the constitution, and that's what the constitution of Ghana. The constitution of Ghana. And you broni bi na de baye. Eya wona ana o maame ana o papa bi a ebia wetwam ana wawu ana yempanifo bi ana mo ho ani eni ho ana mo amoda ho te ase ya dwenkyira ya gege ya kekese ani na de build bi a friend constitution. It is our constitution e ho no. Enye some book bi e bi nsi da. Eya me ne wo adwene kyere and your friend constitution. Adwene kyerɛ a ɛbɛboa me ne wo ɛde abɔ ye ho ban abɔ ɔman ne ho ban ɛna ye nyina ɛde ato krataa so yɛfrɛ no the 1992 constitution. And do not think say ɛyɛ ɔsono maame Madam Torkornoo or some exceptional being bi a constitution no ɔno nko na wɔ ho kwan sɛ ɔkyerɛkyerɛ mu tie. Mema wa adwene nya wo say politician bi ti radio so na TV so a ono enko na Nyankopon ama no ho kwan say eye 1992 constitution a tailor for mason for hairdressers eye doctors teachers obi a oye Ghana de bia ede na adwenkyere ba ye kyekere no omo nko na wo ho kwan ye nyina wo ho kwan say constitution no ye be kan na ya te ase na ye mana boy nyina ho ban. So do not see yourself say constitution de asuo na nipa bi nko na wo eye entitled to break down or explain the constitution and a majority of you Ghanaians deceive mu abedru there. Nobody is entitled to explain or interpret the constitution than the Ghanaian. Some people have been given the mandate that officially, when there's an issue, they can sit and make it official. But we all as Ghanaians, unofficial or official, we have the right to read the constitution and interpret it. And the basic thing is that we need to be reasonable. We need to reason. Our reasoning level should be to the point where we can read the constitution and understand the constitution. So if somebody is misapplying the constitution, you and I, constitution we nurse ni na chiro constitution we tailor ni hairdresser inti ya ma wo nkoa mbe wa adwene se wo na wote ase. So we should all understand this. Over a period of time no nipa bi create ade bi ato Ghana say yo nipa kuo bi a omunkwa na read the constitution. That's not how it's supposed to be. Yo nipa kuo bi a omunkwa na entitled to speak on the constitution. That is not how it's supposed to be. The constitution should be a basic document. Every Ghanaian should be able to read and understand. The one ko school kra an kenkan on to mean kind brofono. I will see a to me manipa constitution. That's it. If you say a sani pana one ko school no na drink e ka ho and a mayor year day ye di constitution by 1992. JJ Rawlings edi ni me de bae. Enti enya Rawlings nkwa adwene. Enye asimesi nkwa adwene wo eneme. Enti aba constitution mama ye common sense ni nya adwuma. Mama me yemfa title ne nkwa ma judge for. Mama yemfa ma politicians. Mama yemfa ma nipa bia. Oma adwene yo mo say because they are in politics no, they have the right to interpret or only speak on the constitution. Na ye maame na oye hairdresser no, ye nua na oko school no, ye nua na oye welder no, ye nua na oye mine ni no, and I say ye nua bi na oton nyama na otumi kan no, only right. We all have the right to read and understand the constitution equally. What am I saying? Now, let's move forward. NOB Kano, the Constitution of the Republic of Ghana should be added to the syllables of Ghana schools. I will say I will say a part. And I remember when we were in school, social studies, we had some part of the Constitution in that book. But in Kwasiafo we started school, no, we don't even know anything about the Constitution of the Republic. I was from class 5. You started the Constitution, you were a Constitution subject. I was saying your school no, you the Constitution no, Sibiani reading books, bit say life skills book, social studies book, Arabic book no. I was say Constitution a topic. Enquirano ebe read the Constitution. Teacher ni beba kenkan page by page. Ondu JSS 3. Now on every part of the Constitution of Ghana. It should be part of it. And I expect the incoming government to introduce this. Add the Constitution to the syllables. Enquirano from class 5. We need to infuse the Constitution in our day, in our daily life, in our education. So I expect the NDC government, when God helps them to come to power, they should infuse, Professor Nano Pokwajimamu should insist that the Ghana Education Service add the Constitution, makes it a whole topic on its own. It should be a subject. That we have the Constitution as a subject, that every kid, by the time they get to JSS 3 or junior high school 3, no, that kid knows about the Constitution, every single page of the Constitution, so that we, the ordinary people, they call us, no, we can also defend ourselves. Because that gap, and then some judges, some lawyers, some stupid criminal individuals in Accra, sitting on TV, no, intimidating you, the Ghanaian, and taxes, Ghana. So we need to make sure the Constitution is it becomes a subject in school. We need to be distributing Constitution book to the kids. The schools need to have it in school. I will say a chema obienya 1-1. Now edu Constitution subject. You're reading the page by page. And then your page 23, what does it talk about? Chieftaincy affairs. The kids need to be taught, or they need to be taught the Constitution. They need to be abreast of the Constitution. They need to know what the Constitution entails, so that as they grow, kwasiebin to mean free Holland in Bambekase, or school Holland, or Bedi Ghana so. We need to get these things right. And I will plead with Professor Nano Pokwajiman that she should add this to her conversation. She should tell the people that when the NDC government comes to power, the Constitution will be a subject in our primary schools all the way to the senior high schools. That's how it's supposed to be. We need to teach the Constitution in schools. All right. Now, team, stay with me. Int'l court, the CNA. Now, Yanko Tie the first part of the CEO court. Now, me betrawa debi. Afenyo marking ne ex-party na or the court court no. Ex-party application na ono kwa court one fre obianka ho okoye no. So what kind of document ni here? Because ende no afenyo marking court no. The last time no, our catch Supreme Court say ministers and MPs miensa ho asem and so okọ parliament documents moi a MP for a 9 wasem and Alban Bagbin a rulie. May show how inconsistent the Supreme Court is, how they don't take details seriously because of corruption. You see, when you are corrupt, what you do in the say, you always try to cover up details. And what most corrupt people do in the say, because details are important and details majority of the time expose corrupt-minded individuals, they try to give less attention to what we call details. In Tisawusha, Afenyoma can call court, he was talking about 3 MPs. And so over Parliament, Adia Alban Bagbin Jina so take a decision now. It was about 4 MPs. In the first place, Afenyoma can Adia Jina so call court, it is wrong. It is a lie. And the Supreme Court is not supposed to entertain it. Into the case Krano in the first place was not supposed to be called. The Supreme Court was not supposed to entertain Afenyomakin. Into reading Afenyomakin, what we call the ex parte application, the second point now, or say, an order restraining the Speaker of Parliament from pronouncing on any motion in Parliament directed by Right Honourable Andrew Esiama Amwako, the current Member of Parliament for Mena in the Ashanti region and second Deputy Speaker of Parliament, Honourable Cynthia Morrison, the current Member of Parliament for Aguna West in the Central region, and Honourable Kojo Asante, the current Member of Parliament for Suhum in the Eastern region in the current 8th Parliament of the Republic of Ghana, from vacating their seat on grounds of leaving his political status as an independent candidate at the time of his election to Parliament to another party and leaving the party of which they were members at the time of their election to Parliament to become independent members of Parliament respectively. Inti uche Afenyomakin Adia Ojina so ede court in the first place Madam Torkornoo and Madam Torkornoo jitu muna. Afenyomakin went with 3 MPs. I'm trying to take this off. Sorry. Afenyomakin call no okokache Supreme Court say MPs miensa mo MPs MP ena ema Alban Bagbin Jina so ebu asem no enso ukọ parliamenta na eye MPs 9 omo ho asem ena Alban Bagbin take a decision or take into what will make the Supreme Court take half truth and try to judge or make a ruling on half truth, because you cannot go to court with half truth. And when you go to a parliamenta, you will see this. I'm trying to get you everything. Moma yankonkotie the Chief Justice and the Supreme Court timer Speaker of Parliament the lawyer Kasaye.
And so that was taken into account before the court that makes the extensive orders relating to even 4 parliamentarians. When the writ itself affected 3 parliamentarians, it didn't even include Article 97, 1 each. And so all of those orders were made based on some of those findings. And I'm saying that, and the position is that the first defendant, based on these things, expects that in order not, especially when the court reaches the conclusion that on the balance, there was no balance, there was just one side of it, because it was an ex parte application, and they were ahead. What was the balancing? Sorry. Yes.
I thought we were just responding to a very straightforward.
Oh, yes.
But now, the case that we are peering into the substance of the motion itself, I would urge you rather to restrict yourself to the objection that and answer it, whether it's scandalous or it's not scandalous.
It's not scandalous.
My problem is if your learned friend on the other side has raised these matters and you think it's not scandalous, you don't have to, as it were now, veer into the substance of the application itself.
My Lord, I needed to demonstrate that these things were not just said
just restrict yourself.
My Lord, I thought I was doing that. And so, as far as I'm concerned, apart from the use of the word scandalous, which he just used, he doesn't demonstrate how scandalous it is based on the context of the application that I have before.
We allege that the Chief Justice is breach of a constitutional provision. What are you trying to convey?
It may have been by reason of inadvertence. But if that's a statement of fact,
was it necessary for you to add that in your depositions? For you, what exactly were you trying to achieve? By adding the point that the Chief Justice was privy to a constitutional breach. I think that is the point it was.
Oh yes, but the point is that if she was privy to it, her ruling must reflect that. If it doesn't, it's one of the grounds upon which I'm urging the court to set it aside.
So, Speaker of Parliament lawyer, the Okache Supreme Court say, "After making Baha Abekase, MPs me and someone some and Alban Bagbin Jina so ebua na some or speak Parliament. Nanso anya no kre. Nipa ye come one some omo ye 9. Inti eden na after making eba Parliament ebedi eba Supreme Court ebedi atrochire mo say nipa miensa en wasam and Alban Bagbin ejina so ebua say NDC majority. Ena judge for much was oh na asana woka no ya pese ebusa say den na woka say Chief Justice Krampo no de oye no entwa ye omo ntia say obi beka say Chief Justice take decision bia sad decision no scandalous entwa ye into omo problem no say the word scandalous omo problem no say aden na woka say Chief Justice decision bi o take ye no based on the afinyoma kende ba no entwa ye enti de enti na emane kasa. So Chief Justice Akasam ne entwaye and even Supreme Court it was something we call review. And your appeals court because you a court no it's not perfect. It when somebody says the Chief Justice took a decision and that decision technically it was scandalous. It was basically the ruling was not based on the facts because the facts and they say when you go to Parliament 4 MPs in 170 eka. Afenyoma can the MPs 3 in 170 buy. So it means Afenyoma can brought a lie for the Chief Justice to rule on. So for the Chief Justice failing to make sure the details are right, the Chief Justice has committed a crime and it's scandalous because we expect the creme de la creme, the biggest court on the land, to do its checks, dot its I's, cross its T's before it makes a judgment. Finished. So how can we be here that we are dealing with half truth? Because after Afenyoma in Parliament, time Alban Bagbin eka say MPs and 9 abaku free NDC miensa free MPP we you omato akonwa no ade achi no Parliament krano they were supposed to do what? They were supposed to in fact draft into Alban Bagbin ruling no na e was a Parliament e de ko enkra time into redia so oko Parliament documentation mu a there was a memo Alban Bagbin from Parliament no release here after Afenyoma court no 21st of October 2024 editor of database chamber reporting office of chamber reporting memo say pursuant to regulation 551C and 0 of the Parliamentary Service or Staff Regulation 2019 CI 118 explain why a disciplinary action should not be instituted against you for photocopying the drafts Hansard of Thursday 17th October 2024 and making same available to some other persons without authorization. Your response should be submitted to the editor of database chamber reporting by 4 p.m. on Wednesday 23rd October 2024. Inti the CNSA after Alban Bagbin making sa declaration of Parliament what happened and they say sa declaration at the end of the day everything that happens in Parliament it was say wie na yehu se mistake bi animu a na eden speaker sign and sign a official document. Now the moment ye be bibi of Parliament yen sign ya speaker engine tumu entimu so no it is a draft enye document sebio obi abetuma gina so take a decision. Until that ruling from speaker that ruling was not a complete statement and I say a confirmed ruling from speaker. If you say now the ruling now make it was supposed to be entered into the document in Parliament to make it an official ruling. Now what happened? And they say, "Adie bechino ena omo parliament no one be a printy the ruling that has not been officially endorsed to be an official ruling no and de ma afenyo marking so on fanko court." Int'l ma speaker ni breye ka say document now de ma afenyo marking coin a draft document. Then I draft document and the be some fan court. If you say every time they sit in parliament, what they do is they go through all the things they did the previous day and see say if there was a mistake somewhere, they correct it. After they do the correction, then it is endorsed to say the previous meeting has been endorsed to be an official or valid document. Afenyomakin took a draft document that has not been endorsed by Parliament. Into the document Afenyomakin took to the Supreme Court, na sad document, and yet they're in the final document of Parliament. Yes, Speaker of Parliament, the lawyer the Supreme Court to say, you have judged on a half case or on a half truth. What Afenyomakin brought was not even an endorsed document from Parliament. It was a draft. And even after that, Afenyomakin came here to say things that were not accurate because Speaker of Parliament ruled on 4 MPs. He did not rule on 3 MPs. So it is scandalous for the Supreme Court of the land to say they are ruling on a half-truth, on a draft, on a document that is not totally official or endorsed by the Speaker. So Afenyomakin is just bringing a sheet of paper to come to Supreme Court to go get a ruling. And then Speaker of Parliament, lawyer and catcher Supreme Court said, this is not right. You are not supposed to do that. It is scandalous. A whole Supreme Court cannot get its facts right. And another judge in the case, my name Kasa. Now, I didn't know also say it is scandalous, but the facts are the facts. How many MPs in the Council of Parliament? 4 MPs were the MPs are Speaker really almost so how did it happen say in Parliament in Supreme Court we are talking about 3 MPs. Now let's move forward. Now this is also another thing that happened. Speaker lawyer no raise the issue be that the ruling of the court is based on parliamentary proceedings that has not been approved by the Speaker. Now, so study pa. Even the next day, na Speaker by they still did corrections in Parliament on the previous meeting. Previous meeting na Afenyomakin ejina so called Supreme Court the next day na speak about Parliament they had to correct some things in the previous meetings. So Afenyomakin went to the Supreme Court with a document that was a draft that was not an endorsed document. And intina ostadia omoko Parliament the next day you saw the Speaker forcing Parliament the clerks there to make corrections to their previous meetings.
Speaker, thank you for the opportunity. Mr. Speaker, item number 5 on page 9. Mr. Speaker, the statement made by the Honorable Minority, the Honorable Akuffo, Mr. Speaker, was in respect of the fact that 4 members of Parliament whose names have been listed have breached Article 97(1)(g) and H. It was not a mere allegation, Mr. Speaker. So the appearance of who were alleged to have been in breach, I believe that it does not reflect the true statement made by the member, because it was based on the statement that the Speaker proceeded to make to give information that you gave to the House. The Speaker further, in indicating the names of the honorable members so named, their current situations and circumstances were clearly stated in the motion paper. So that, for instance, the first name, Peter Yaokwachi Aka, the NDC member for Amenfi Central, and now an independent candidate. Mr. Speaker, so the statement contained these clear facts, and therefore it's important that they reflect in the in the proceedings as captured for purposes of correction. Mr. Speaker, I thank you for the opportunity.
Yes, Honourable Member for Medina.
Thank you, Right Honourable Speaker. Right Honourable Speaker, I also want to draw your attention to the same item, the paragraph 5, the ending statement, which is majority caucus in inverted commas. Mr. Speaker, I think the true intention will be reflected there when we say that the minority caucus staged a walkout instead of a majority caucus in inverted commas. So if the correction can be made to reflect what was there. Thank you.
Yes, Honourable Member Bolsa Saf. Is that okay? Yes, from the distance I can't see. Honourable Member for, you are all right? Thank you, thank you. Table office, kindly take note of the comments made by the members. Please cross-check from the records and capture what is on the record of the House.
So you see what they were doing. This was the day after Albert Bagbin took that decision. The next day they came, they called something a vote and proceedings. What they do is they sit, and what they do is they correct every single thing in the previous proceedings. Whether there was some votes cast or whatever they decided on, they come back before Parliament's new session starts. They correct everything. The moment they are doing that, that moment, the activities that happened the day before are just a draft. It has not been adopted. So what they will do is they will adapt before, when they finish doing all these corrections, they will now adopt it and endorse it. Then it will be part of their parliamentary records. So Akuffo Nyomakin went to court with documents that had not been corrected, documents that were just drafts. And then, Ekache Supreme Court to say, the guy, you will even listen to him, ex-party application, the document he brought are not documents that were adopted and endorsed. So in the first place, it is scandalous for the Supreme Court to be ruling on a document that has not been adopted and endorsed. That is what the lawyer was saying. Meaning, in the first place, we were not even supposed to be here. If the Supreme Court had done its job, if the Supreme Court had done its due diligence, if the Supreme Court had taken its time not to make this whole thing an ex-party process, if the Supreme Court had taken its time to allow the other part or other party to also bring their grievance, the Supreme Court would have known that Akuffo Nyomakin's documentation that he presented was a draft document and that it wasn't a document that has been adopted and endorsed. In the first place, the beginning of this whole thing was scandalous. The Supreme Court, which has the oversight responsibility to make sure, say, every document that comes before Mahama and her battalions, those documents have gone through the litmus test. Those documents are legit and factual. The documents before them, which they ruled on, the documents were half-truths. But the court said they don't care. The Chief Justice, and in the Ghana for say, upon all the law they have learned, let us use common sense here. And common sense, obia onkanu krebiano, there are two things they don't want to apply: common sense and paying attention to details. They deliberately ignore details because the moment they try to pay attention to details, they will say they are corrupt. And that is what is happening at the Supreme Court. The Supreme Court deliberately ignore details because when they decide to take care or monitor or pay attention to details, Akuffo Nyomakin will not have a case. In time when you're marking and the Chief Justice, and the Supreme Court itself, it is not even ready to open it as itself up to make sure detailing or making sure the facts are true. They don't care because they are in a rush to rule for a corrupt minority leader after your marking. Because so we a judge now to wanna say an opposing lawyer raise the issue here. It goes against the integrity of the court. You are supposed to protect the integrity of Ghana Supreme Court. And what you do is that you call for a detailed document. Argentina can't lawyer and say, why don't you provide us with a real document from Parliament? Then sorry will give you the adapted and endorsed document. Now in that document you will see say Alban Bagbin ruled on what we call 4 MPs and not 3 MPs. Now that's fine. Now Alban Bagbin's lawyer feels sorry, and so he raised another issue. He raised an issue. One of the judges are not a panel or a former NPP parliamentary candidate. Jesus Christ, judge are not otisono or no ebe bua semno or a former parliamentary candidate. Wejinama MPP, waye Syria kolada, waje card da. And Alban Bagbin, lawyer, and a raise issue in the say, Madam Judge, your colleague sitting there, even though he is a judge of the Supreme Court, he needs to recuse himself. Because Alban Bagbin application say the judge na otuwono, gawuno se DNA friend sano. He is a member of the NPP. Now, may I explain it, the Chief Justice and the response. This was the response of the Chief Justice.
Rises from some
my lord, what the Supreme Court?
Right to my lord, the Chief Justice. To him being impaneled in this matter arises from the fact that at the point in time he was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you said no. I think you said enough. Can you resume this?
Very well,
Let's go.
And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
Very well. And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you said no. I think you said enough. Can you resume this?
Very well,
Let's go.
So, the Speaker of Parliament's lawyer, because in the application, Speaker of Parliament, Yankan said the response now, Speaker of Parliament, at the core, Supreme Court, or say, judge near friend NS Gauno, or MPP ni, yenina yenim. And Alban Bagbin lawyer and Chief Justice say, even though he is a judge now at the Supreme Court, Alban Bagbin and his lawyers believe, say, his earlier affiliation with the MPP could influence, can influence his decision on this matter. Because the matter we are treating in the Supreme Court today, it is between the NPP and the NDC. A purely political matter. Speaker Alban Bagbin lawyer Chief Justice say, wouldn't it be right? You have so many judges, over 34 Supreme Court judges. Can't he recuse himself to protect the integrity of your court? If even he's going to be fair to just take the doubt out of the minds of Nana Akufo-Addo's word, naysayers, no, or people who are still contemplating whether the court is legitimate or illegitimate, or the court is biased or not biased, no. Why don't you take this man, who is now a Supreme Court judge, off this matter? If it had been any matter which did not involve the NPP and the NDC, then nobody will have an issue. But wouldn't it be good, Sir Chief Justice, ubeyi man way every case in so send the doubts in the minds of people? Already people are saying your court is political. Already people are saying you have politicized the court. Already people are saying, say, you people are working for the NPP. Wouldn't it be great for you to clear that thing from the minds of people? Chief Judge Kachen's on Tenassi on person better no. Now, you see, when you read Ernest Gawu's profile, and this man is part of the panel, Omu decide here, Omu rule say the Supreme Court has jurisdiction. Omu the power to step into the rulings of a parliament. Now, when you read Justice Ernest Gawu's profile very well, this is what you see. Whilst in private practice, he was active in partisan politics from 2009 to 2016, serving as a constituency chairman and parliamentary candidate for the New Patriotic Party in the whole West and whole Central constituencies. He resigned on 16 September 2020, which was the same day he was appointed as a High Court judge. This judge, Ernest Gawu, was the constituency chairman, a parliamentary candidate. In fact, the day he resigned that he's no more a parliamentary candidate for the NPP, no, that was the same day Akuffo in 2020 moved him to the higher court. So, no matter how you see this, this judge at this point is not supposed to be part of this case, especially when you have so many judges on standby that you can place or to replace this man on this panel. The Chief Justice said no. Now, you don't know something? The President now, Chief Justice, we are set with all the skirmishes. You see, moi, law, no. Me, I've not been to law school. You see this statement when they say recusing yourself from a case when you are a judge. So, Opesa summarizing now, in short, no. In short, a judge may be recused if only he has some actual interest, personal, familial, or financial in the outcome of a case, or where he has shown himself to be so prejudiced against one of the parties or the case's subject matter that he cannot be trusted to rule fairly. Now, the Chief Justice's argument today when she was making her ruling, and say, the same parliament actually vetted this man and made him what? And made him a Supreme Court judge. So, as far as parliament vetted him and said he can go ahead and become a Supreme Court judge, nobody can tell her that she should take the man off the case. That is why, at the end of the day, the case be etimiba Supreme Court. Na se eye Chief Justice mame and a case in the fan ho. Na Chief Justice ewo Supreme Court. The best thing for Chief Justice to do, and they said, to recuse herself. Not because as someone on to me, it is because she's related to Nemame. It is because no matter how, sɛ ne maame kora anhwɛ ne mfiri nkwara abrem ana maame ne adapte no ɛna maame na anhwɛ no school a the fact sɛ ɔyɛ ne maame no, it will influence her decision on the panel. It is either going to make her angrier and not to look at the issues well, or it is going to make her have sympathy for the woman for not being with her for a long time. So it is always important that when issues like this comes and you have any affiliation, because this man used to be a member of the NPP and not just a mere member. He used to be a parliamentary candidate. No matter how you see this, he has a little bit of soft spot for the NPP. And this is a very, very important case, sir. You, the same Chief Justice, you call the case exceptional circumstances. So if the case is an exceptional circumstances, then you don't leave any room for doubt. That is why you are supposed to take the man off the case, to take out that misconception and that idea say Chief Justice is trying to rig. Because the moment you keep the man on, even though Parliament sanctioned him to come to the Supreme Court, he is not supposed to be seen as being biased. So to prevent that, in the eyes of the public or the citizenry or people in court, he needs to stay away so that the court or the people in court will have a clear understanding or conscience in following the case. Because no matter what you do, say Judge Way, the chairman or whole central through Ayana during his time or man parliamentary candidate anymore, not panel be or no kanwa. The law now say he needs to recuse himself because say in the corner no relationship he's had relationship with that man before. That man has helped him become a parliamentary candidate before. He used to know this man. He used to work with this man. So logically, reasoning wise, it is best for this judge to step away. And it's now to court. Now your judge. Now oba asamoba yema uba ndi asamono. Yama undi ubanasem. And it's na sebia unya ba kura kunu asemo ba. Nesi ye unse unya ba kunu ena na asema ba. The Chief Justice is supposed to make sure you don't sit on the case. So why would the Chief Justice say upon all these things that is going to create some misconception in the eyes on the heads of people, she still insists to say this man is supposed to sit on the case. And then the chair will say the intent has never been clear for the Chief Justice and the panel. It has always been a biased panel that is there to work for the executive. And I want you to understand the AC or Supreme Court. And when people say the Chief Justice has sold the court's soul and that the Chief Justice or Mahama is doing the bidding of the executive, you are not supposed to compete. Forget about their jargons. We are applying common sense here. We are applying reasoning here. We are trying to let people understand and say, oh, yeah, jaja, oh, nyanyame. You need to use your conscience. Sa adwene da da utimu a wo mpese obepa obi hu na kasa obejantre no sa adwene na wo se boa na a guide in using the law to protect yourself and protect the people before you. That is your core mandate. Now, Mr. S, Mr. P, stay with me, guys. I still have breaking news for you. I'm not done. Now, in court, another issue says here. Chief Justice, or you see where to be in there. The Chief Justice making a ruling, no, or in her submissions or ruling, no, or say, if Afenyomakin had gone to the High Court, the High Court would have still come to them for interpretation. Alban Bagbin lawyers raise the issue, no. Omo can be say, in fact, so we read the constitutional, now we follow constitutional, now person who didn't cry. Nanka or say Afenyomakin echo edien a High Court. But Afenyomakin ended up at the Supreme Court. And the application from the speaker, lawyers say, it is not right for Afenyomakin to even, at the end of the day, come straight to the Supreme Court. Even though the Supreme Court oversees or is powerful than the High Court, we should all follow due process. As far as the Constitution is saying, there is the room, we still have an option to use, Afenyomakin was supposed to use that option. Because in Ghana, Supreme Court is such a High Court. But the Constitution so says Supreme Court such a High Court. But the Constitution also insisted it was say issues like this, majority of them has to come to the High Court. The Constitution recognizes the Supreme Court as being the the highest court of the land. But the Constitution also did not. The Constitution also did not discredit the High Court. It gave the High Court specific role to play in issues like this because Constitution will say due process is very important when it comes to law. Int'l say, even though the High Court, the Supreme Court is there, you have to go to the High Court first. So why did Afenyomakin come to the Supreme Court? Chief Justice started using hypothetical statement in her ruling. Now, when a Chief Justice sits in the Supreme Court and start using hypotheticals, because the probability say Afinyoma can echo High Court or Beba Supreme Court, you cannot say it is definite. No. The probability say case, it could have ended up in the High Court, it is also high. So how can a Chief Justice sit in the Supreme Court and say, if even Afinyoma had gone to the High Court, it could have still ended up on her table? It means the Chief Justice sits in the Supreme Court using hypothetical statements to judge a case that are supposed to go through due process and definite actions. Now, listen to this.
Third, it is the most basic tenet of our legal system that different courts operate in different jurisdictions, and every court is given its own jurisdiction. So the type of cases that can be settled in any court depends on the nature of the dispute. Thus, if someone is challenging that a member of parliament has not lawfully won their seat, that challenge must be done at the High Court in the region that the constituency is in. However, if any two people challenge that the process of electing the same member of parliament did not conform with the constitutional provision, that dispute over the correct interpretation or meaning of the constitutional provision must be brought to the Supreme Court for interpretation. Indeed, if the dispute over correct interpretation or meaning of the relevant provision occurs while the parties are before the High Court, the High Court must, by direction of Article 132, stop hearing the case and refer the dispute over the correct interpretation of the Constitution to the Supreme Court. There are many cases on this manner of resolving disputes requiring constitutional interpretation, including ex parte Senator Rawlings, citation provided. In every given month and year, the Supreme Court regularly deals with cases seeking interpretation and enforcement of provisions of the 1992 Constitution, and every law report issued every month is filled with such cases. It is therefore misinformation and misapprehension of law for the applicant to present that the Supreme Court has no jurisdiction to provide the correct interpretation of Article 97(1)(g), because Article 99 gives jurisdiction over determination of membership of Parliament to the High Court. Article 99 reads, "The High Court shall have jurisdiction to hear and determine whether elected as a member of Parliament or the seat of a member has become vacant, or a person has been validly elected as a Speaker of Parliament, or having been so elected has vacated the office of Speaker. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal." From the above, it can be seen that if anyone raised the question whether a person has been validly elected as a member of Parliament or a seat of a member of Parliament has become vacant as a matter of fact, that person is required to go to the High Court for the High Court to resolve any issues around that question. In the instant case, the records brought to the Supreme Court submitted that the question was raised on the floor of Parliament that by filing nominations to contest as independent members of the 9th Parliament, members of the 8th Parliament should be deemed by reason of the meaning of Article 97(1)(g) to have vacated their seats in the 8th Parliament. Thus, the vacation of seats is not a matter of fact from death or resignation or notice by the parties themselves to Parliament. It is to be taken from an interpretation and enforcement of Article 97(1)(g).
So you see what she tried doing here? She tried to override the power of the High Court because she wanted to take over the case. She knows that if Afenyomakin had entered the High Court, the outcome that Afenyomakin is getting at the Supreme Court, he wasn't going to get. Because when you look at the jurisdictions of these courts. The High Court has original jurisdiction and the Supreme Court has referral jurisdiction. Meaning, there's a reason why the High Court has original jurisdiction and the Supreme Court has a referral. That is why it was very imperative for the Supreme Court to send Afenyomakin back to the High Court for him to exhaust the process there, and that when the process is being exhausted, it can come to the referral, which is the Supreme Court. But in this case, the Chief Justice sits in her chair and tells Ghanaians that forget the High Court. There is no importance to the High Court. It does not have any role. In fact, we as the Supreme Court, we can override whatever the High Court does. Then from the Chief Justice hypothetical statement, whatever goes to the High Court, the Chief Justice from the Supreme Court can just enter the High Court and say, bring it to the Supreme Court. Then it means the Constitution that created the High Court, at the end of the day, the same Chief Justice is undermining the powers of the High Court. So if you're a High Court judge today, your Chief Justice sits in the Supreme Court and says that no matter what, a case can come there, and if she wants that case to come to the Supreme Court, she can quash the powers of the High Court and bring it to the Supreme Court. But there's a reason why the Constitution actually decided to bring a High Court, brings an appeal court before a Supreme Court. Because when due process is followed, then you get to know the real facts of a case. There's a reason why when the issue of parliamentarians and all that came up, it did not directly, or the Constitution did not directly say go to the Supreme Court. It said go to the High Court, because the case needs to be started originally so that we will know. Because you see, the draft that Afenyomakin took to the Supreme Court, if Afenyomakin had sent the draft to the High Court would have referred Afenyomakin, or would have sent Afenyomakin back to Parliament to present the endorsed proceedings. But because the Chief Justice was in a rush, the Chief Justice wanted to go against the process. The Chief Justice does not respect due process. She basically wrote Afenyomakin's application for him, gave it to him and said, bring it to me, and that I will make sure you get a ruling. That is why we are here today. So the Chief Justice is writing his own application and answering his own application and giving ruling on his own application. As we sit here, the Chief Justice of Ghana today is undermining courts in Ghana from her own hypothetical statement. How can you sit in the Supreme Court and make hypothetical statement that if the case had gone to the High Court, it would have come to you? You don't know. You never know. Because maybe if the case had gone to the High Court, it wouldn't have been an ex parte case. So how do you know that when the case goes to the High Court, it has to come to you? The Chief Justice of Ghana, Madam Torkornoo Osnomame, today sits in Supreme Court and undermine the High Court and tells us that even though the Constitution gives the High Court the mandate to oversee these issues, she does not respect the High Court, all because she's there to work for Afenyomakin and Akuffo Addo. That is the problem of the day. That is our problem as a nation. And you see, this is what they are doing. And this is part of the reason why today, that is why today in Ghana, we are all saying our democracy has been hijacked. Now listen to this part.
To the Speaker, or G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. Or H, if he was elected a member of Parliament as an independent candidate and joins a political party. 2, notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original or political party forms part shall not affect the status of any member of Parliament. Now, clearly, with the disputed interpretations alleged in the plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex parte Zaneto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. The plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zanetto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. Even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zanetto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of Parliament and the Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself. Correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of Parliament and the Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself.
So when you listen to the Chief Justice, right? And then Akuffo, because the Chief Justice, the ruling was already prepared. Yes, it was already prepared. It was a ruling that she had already written. This was not a ruling where Omoko shared them 30 minutes or no. You know why? So a person who's a ruling was already prepared. It was when the lawyer for Speaker raised the issue of the drafts. Because if the Supreme Court or the Chief Justice had not already prepared her speech, she should have known that the issue that happened in Parliament for Afenyomakin to run to Supreme Court and the draft document he brought, she should have known that it involved 4 MPs. But because the day na Afenyomakin ever court now on one case application man be presented to him, no, the Chief Justice had already written down her ruling. It is a the ruling now, which my team they are trying to get you. Her ruling was only based on the draft document. But you see, when Alban Bagbin was replying to the Supreme Court, Alban Bagbin made the Chief Justice understand and say it is scandalous because Afenyomakin can cry document it's a draft document that does not cover the original or endorsed the parliamentary documents. Inti, who was a Chief Justice, ne reading is not reading in from the occurring when you take your time, you see, say, it has been predetermined. It was already written. Her judgment was already written. She already had a judgment before coming to court today. Nothing could have changed the mind of the Chief Justice because on no natural application Afenyomakin court the first time, no Chief Justice and a trauma and say onko na onya den on for side we mreno na on grant expert in mano. Into Chief Justice or not throw the case or not turn the case so no judging the case. Now here there. You remember the case of Sal, right? 30,000 Ghanaians were denied or they were disenfranchised. They were not allowed to vote in election 2020. Now the Chief Justice today, there was one thing that she was doing that majority of Ghanaians did not pay attention to. She hid behind the word called exceptional circumstances. exceptional circumstances. Or say, case no, because of exceptional case no had an exceptional circumstance. A case be na exceptional. All because one, some of the people are the respective MPs no constituencies no say Alban Bagbin ruling it take effect. All those people will not have an MP. Won't any reasons. Original so can say or granted Alban afenyo marking the expert in the man or say exceptional circumstance. You see, this is a dissension into politics. The Chief Justice was doing pure politics. Whether the constituents will get a chance to vote or not, it is not up to the Chief Justice to determine. It is up to a parliament. Nobody forced the respective MPs to go independent. So disenfranchising or not allowing their constituents to basically enjoy their service for the rest of the parliamentary sitting, no, it is not up to Speaker to decide, the Chief Justice to decide. Now, the Chief Justice was veering into a very tricky arena because one, say Obi, Ankasa sorry no kasa me MPP ni me pese me koye independent. It is not up to you, the Chief Justice, to say nipa na oye penyina willingly we decide say obeko independent no ne constituents na omo at the end of the day will lose that seat no and I say omo nya MP no enya wo na obe decide parliament they decide. Chief Justice raising issue be say san conform no ko independent no what is going to happen is say what if omo da the committee bia no it is up to parliament to make that decision. Somebody the committee and I say first deputy speaker of parliament. It is the parliamentary and I say a parliament to at the end of the day find solutions to that. It is not your job. As the Chief Justice, it is not your job to tell Parliament how an MP's constituents will vote or not to vote. It is up to Parliament to make that decision. As a Chief Justice, say Obika say our position or the committee so not so obeko parliamentary or obeko independent. Now say at the end of the day or independent. It is not up to you, the Chief Justice, to sit in the Supreme Court and determine say I didn't move in the panel because of the committee. So at the end of the day, Parliament knows how its own laws work and they know how they can fix their problem. So you could see say the Chief Justice she was descending into politics. She was doing pure politics and not trying to look for the facts. Now listen to the Chief Justice here.
The Constitution enjoins the Supreme Court to make orders that are appropriate for giving effect or enabling effect to be given to its final declarations on the correct meaning of a constitutional provision. And the Constitution is so serious about ensuring the obedience of such orders that it creates the offense of high crime for failure to obey such orders in Article 2.4. Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it, this court found it expedient to compel the parties to allow an early hearing rather than make an order that would last only 10 days. This is the reason for the Supreme Court's orders abridging the 14 days allowed for defending a constitutional action through a statement of case and directing the parties to file their respective statements of cases within 7 days and present the issues for resolution immediately thereafter. If the parties had complied with the court's orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last. Compliance would also have enabled this court to dispose of this case by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
So you see, what she was doing was pure politics. As we speak today, so I will say the decision you are taking is based on, say, some of the MPs now become independent and say at this point, Alban Bagbin Jina Embrabiso no you omoto akonya say omoko independent, their seats are vacant. Send the MPB who and that. Chief Justice, are you going to decide for Supreme Court what to do, Parliament what to do? When Parliament take a decision in Parliament, they know how to correct their own decisions. Send the MPB who are. Is the Supreme Court going to tell Parliament to immediately replace that MP who died? No. You are just delving into tricky politics. This is basic, and this is clear that you are being biased. You are doing pure politics. In 2021, Madam Torkornoo was on the Supreme Court panel that threw away the SAL. Was the SAL issue not also an exceptional circumstance? SAL, over 30,000 people were disenfranchised. The Electoral Commission deliberately decided to take them out of the elections. Madam Torkornoo, you were on that panel. You did what? At the end of the day, what you did was that you did not, at the end of the day, that panel that threw away the case, were you not part of the panel? So you want to tell us that today, the MPP MPs who are voluntarily, they have decided to go independent and forfeiting their own seat in Parliament and also forfeiting their membership in their own respective parties, in their party, Today you are telling us, say, because they are MPP and they are forfeiting their seats, the Speaker of Parliament does not have the right to declare their seat vacant, but you have the right to tell us, say, the people of SAL, under special circumstances, they don't deserve to be heard and to vote. Because you were sitting on the panel in 2021. And what did you say? You said the people of SAL, and your special circumstance, it was thrown out of the window. But today, you are so angry, you are sweating, and you are trying to make it look like these 3 MPs or 4 MPs who voluntarily decided to go independent, knowing the rules on the ground, knowing their own respective parties, Omankasa political party, the rules on the ground that when the moment you declare that you are not going to go on their ticket, you forfeit your membership. You today, you are defending those people. What about the people of SAL? The people of SAL, you sat on that committee, that panel, and threw the case out. Wasn't it the special circumstances? Wasn't it Ghanaians who were being disenfranchised? Wasn't it the same Ghanaians who pay taxes for you to be able to feed your family every month? You see, the biasness in this Chief Justice, right? The deliberate biasness and the corruption that has engulfed this our court at time. And I say this because, you see, we have a Supreme Court made up of party foot soldiers who are selective.
Abusuya huene ensima ekoso our political highway so Chief Justice and international media for no say ne cap no ayema say ne atro bia say or the political affiliation eno ntina emaning di asem no say or the gunu ho anima say emagana fo bia hu say say o the political party back a say and I'm say afenyo markings edinensem ekoko dane na afenyo markings so MPP ntino issue no opese obua edibo Bagbin so no ono so ono ontiase ne entiase echna no enema international media phones be ma omo ababe expose Chief Justice Torkornoo enye asem keto akra ye be abidwafo asese omo je pene kokoti sa audio edemaye medamase.